You may have heard that a will does not eliminate probate, and that is absolutely true. If the will is going to be put into effect on your death, there must be a probate. If you are listening from a jurisdiction or a state where probates are lengthy, complex, expensive, that the legal fees are huge because they take a percentage of your estate, then absolutely, I would 100% agree, avoid having a will and a probate. But I am talking to you from the state of Washington. And in the state of Washington, our probates are not that big, expensive, complex process, unlike other states. So, but it still holds true. A will must be probated. The question to ask is, does it make sense to probate a will, or does it make sense to set up your estate plan to avoid a probate? So that's really the issue. In a will, what we will almost always include here at ELG Estate Planning is what we call a supplemental needs trust. That's an asset protection trust. What that means is any of your beneficiaries, when they receive their assets, we either know we'll put them into the trust, or we'll make the decision at the time of your death, do we put the assets in the trust? Why do we do that? Well, if it's for a surviving spouse, the reason that we do that is any assets in that trust are not counted by Medicaid against them should we be looking at having the state pay for the surviving spouse's care. Other reasons, maybe there is a beneficiary who is on other needs-based government benefits, SSI, Section 8 housing, or something like that. In that event, those assets don't interfere with that beneficiary continuing to receive their government needs-based benefits. Maybe it is a person who is a beneficiary of your estate, and whatever their circumstances are, their marriage is such that you're concerned that there may be a divorce, or that the other person in that marriage is too controlling, that they will take all the money that you want to go to your beneficiary, or lifestyle issues, spending issues, drug, alcohol issues. For those reasons, we will put in our will protections meaning a trust, and the trust will be set up depending on what the situation is for your beneficiary. So here in Washington, we definitely use wills for asset protection. So if you hear that a will doesn't protect assets, what is unstated, but what has to be implicit in those facts, is that that will doesn't have any protections in it, any trusts in it. So you're hearing a simple will. The simple will says, hey, on my death, everything goes to my spouse or my kids, and there's no trusts that are included within that will. If that's the case, then yeah, there's no asset protections, and then you have to ask yourself, well, then why are we setting up this estate to go through a will and a probate process? Is there a better way to do it? Frankly, a better way to do it to avoid probate in a very simple situation may be to have your bank accounts pay on death to your beneficiaries, and your house transfer on death via transfer on death deed to your beneficiary. So what is right for you depends on your situation, what your family dynamics look like, what your assets look like, and what state you live in. So as I said, I am talking to you from the state of Washington, so very much concentrated on what our laws are. We're also licensed in Idaho as well. But if you are listening from any other state, then please take the information that I'm giving you, but go ask questions of your estate planning and elder law attorney in the state where you live, because every state's laws are different, and I would feel terrible if you're relying on everything I'm telling you to say, oh, that works in the state of California, because frankly, we know in the state of California, you don't want a probate. You'll want a revocable living trust or some other type of estate planning platform. So hopefully you take this information, learn from it, and then speak to the attorney in the state where you reside.